right, everyone, settle in. Roll cameras, and action! I want full steam from the locomotive as it crosses the bridge.
The Supreme Court of New Zealand sits at the apex of the nation's judiciary. Yet for all its constitutional authority, its doors are securely locked to general grievances. We see the weight of those locks in the 2026 judgment of Re Nand, an appeal driven entirely by a self-represented litigant. The dispute originated in Auckland in 2013. Daya Nand, an employee of Idea Services Limited, faced a workplace investigation over alleged misconduct. That investigation ended in a settlement and his resignation. But Nand maintained he was misled into signing that agreement, demanding a full review of the facts to correct what he saw as a profound injustice. He pushed that demand to the highest court in the country, but his appeal never reached a judge for a hearing on its merits. Instead, it was administratively rejected at the filing desk by a deputy registrar. When an individual approaches an apex court seeking the correction of a wrong, they expect a judicial audience. In reality, they hit a wall built of strict statutory rules. This wall is constructed of statutory gateways, rigid legal thresholds designed to manage appellate workflow. Trained legal professionals carve their arguments into the precise shapes these filters demand. Unrepresented litigants, arriving with raw, unfiltered claims, simply bounce off the barrier. The justice gap functions as a linguistic barrier. While the court system remains physically accessible, its jurisdictional requirements create a technical threshold that many citizens cannot cross without a translator. To see how this operates in practice, we have to trace Daya Nand's legal progression chronologically, observing exactly where and why the system shut him out. Analyzing a dismissed appeal requires ignoring the underlying personal conflict for a moment and looking directly at the architectural wiring of the judicial hierarchy. This is the New Zealand judicial hierarchy. To understand the Supreme Court's rejection, we have to start at the foundational level. Step 1 was the Employment Relations Authority. Following his resignation, Nand filed a personal grievance claim alleging constructive dismissal. The authority split its findings. Part of his claim was filed out of time, and the portion filed in time could not be proven on the balance of probabilities. Nand escalated to the second tier, the Employment Court. Because he missed the deadline, he had to apply for leave to challenge the authority's determination out of time. Before the court ruled, a settlement agreement was reached, and Nand's representative filed a formal notice of discontinuance, effectively closing the matter. Nand later attempted to reopen the case. He claimed his representative had misled him into accepting the settlement. The Employment Court struck out this application entirely. Procedural finality at these lower tiers, like binding settlements and formal strikeouts, drastically narrows the viable pathways for any future appeals. That procedural narrowing becomes a highly restrictive bottleneck as we ascend up to the third tier of the system, the Court of Appeal. Here, Nand was confronted by a specific statutory gateway, Section 214 of the Employment Relations Act. Section 214 does not allow a general review of facts. It mandates that an applicant prove their appeal raises a specific question of law. Even if a legal question exists, there is a secondary requirement. The grounds for the appeal must be of general or public importance. The Court of Appeal declined Nand's application. They ruled that his proposed appeal failed to meet either of those specific legal definitions. At this tier, the court is no longer evaluating whether a litigant was treated unfairly in the workplace. It is strictly judging whether the claim fits the precise definition of an appellate legal question. That specific rejection at the appellate level immediately triggered the final, desperate escalation up to the absolute highest tier of the entire justice system. Nand filed 2 separate applications for leave to appeal to the Supreme Court. Both were immediately declined for filing. The first application sought leave to bring a criminal appeal. This was a clear jurisdictional failure. Section 214 proceedings under the Employment Relations Act are strictly civil. Because the matter was not a criminal proceeding under the Supreme Court rules, the court had zero authority to hear it. The second application sought leave for a civil appeal. This was blocked by a harder statutory stop. Section 68 of the Senior Courts Act 2016. Section 68 contains an absolute prohibition against this specific route. The Supreme Court cannot hear an appeal against a Court of Appeal decision if that decision was simply a refusal to give leave. The Deputy Registrar's rejection was an unavoidable administrative necessity. The law provided no jurisdiction for the paperwork to even be processed. The question remains, is there any legal mechanism to bypass that blockage? There is a technical route known as a leapfrog appeal, bypassing the Court of Appeal directly to the Supreme Court. Activating this maneuver requires Section 214A alongside Section 75. It restricts appeals strictly to questions of law, demanding proof of highly exceptional circumstances. The Supreme Court noted they did not process Nand's paperwork as a leapfrog appeal. He had argued a general case for investigation, rather than explicitly pleading the highly specific grounds required for a direct bypass. The ultimate disadvantage of the unrepresented brigand is fighting with generalized arguments of fairness in an environment that only responds to highly specific procedural commands. Stepping back to view the entire system from a distance, the sheer difficulty of navigating this jurisdictional labyrinth becomes entirely and undeniably obvious. Self-represented litigants typically arrive with a narrative of perceived injustice, but the Supreme Court can only act within the specific jurisdictional mandates provided by Parliament. The court is strictly bound by statute. It cannot legally bend its own operational rules to reinterpret or rewrite poorly formulated paperwork on behalf of an applicant. A perfectly operating appellate system inherently shuts out those who don't speak its specific technical language. Resolving this tension means shifting our focus away from trying to fix the apex chord and instead completely rethinking the foundation of dispute resolution itself. True access to justice requires resolving disputes proportionally at the base level, ensuring the conflict ends long before complex appellate navigation is required. Modern frameworks, such as the 2025 Disputes Tribunal reforms, address this by prioritizing the substantial merits of a case over technical procedure. By shifting the burden of translation from the citizen to the tribunal itself, these forums resolve mid-value disputes before they ever encounter the procedural filters that silence Nand. Everyday citizens should not be forced to navigate a multi-tiered appellate structure without legal counsel just to have their evidence reviewed. As Re Nand proves, possessing the fundamental right to appeal is meaningless unless the system speaks the language of the people, or the people have access to the language of the system.